Hey there, this video is about how to get your felony case reduced to a misdemeanor at your preliminary hearing. My name is Veronica. I am a criminal defense attorney here in Los Angeles, and I help people who have been arrested put their criminal cases behind them so that they can enjoy their lives and their freedom. And again, this video is going to be about how to get a felony case reduced to a misdemeanor at your preliminary hearing. Now, there are multiple ways to get a felony reduced to a misdemeanor, but this is just one of them. This is one that I feel is underutilized. Many times I don't see attorneys making this motion or trying for this, and it's a missed opportunity. So let's get right into it. Okay, so first of all, I'm talking about getting felonies reduced to misdemeanors. Now, this does not apply to all felonies. This only applies to wobblers. Wobblers are felonies that could be charged as either felonies or misdemeanors. And there is a long list of them. Excuse me. Some examples are some types of burglary, assault with a deadly weapon, criminal threats, it's 422, or a really common one is PC 273.5A, which is corporal injury to a spouse. It's a type of domestic violence. So if your felony is robbery, if your felony is murder, you're not going to get it reduced to a misdemeanor via this motion that I'm talking about here. You're not going to get it reduced at the preliminary hearing by making this type of motion. So second, what is a preliminary hearing? Right? A preliminary hearing is a hearing that only happens in felony cases. It happens at the end of the pretrial stage. So basically at that point, usually there have been some negotiations and there's no deal that the DA and the defendant both agree to. And so there's this hearing, this probable cause hearing, where witnesses, where the police officer show the evidence that they have in court. Not all of the evidence usually, but they show a good deal of it in court. And I mentioned earlier a motion. So the motion that I'm talking about, and I'm trying not to get too technical here, but it's called a 17B motion that you make at the end of a preliminary hearing. So how this works is that, okay, the preliminary hearing goes on, right? You have cops, you have witnesses going up on the witness stand. Sometimes they're showing evidence on the projector, they're showing video. They're showing the judge and the people in the courtroom, okay, here is the evidence that we have. Here are the allegations against the defendant, and here are, like, the basics of it. Now, at the end of the preliminary hearing, one of the motions that the defense attorney can bring, if this is a case where the felony is a wobbler, not just a straight felony, is a 17B motion, and that is 17B motion means it's a motion to reduce the felony to a misdemeanor. And this is where the defense attorney is asking the judge to do this. Now, why would the judge do this, or what does the judge look for? So there are four basic things that the attorney needs to argue and that the judge should look for. First of all, the nature of the offense. So for example, if it's a criminal threats case, this is where one person says, I'm going to kill you, to another person. Okay, well, did the person, when they were saying that, have a knife in their hand? Because then it's probably not going to be reduced. Did they have nothing and they were completely unarmed and they were obviously unarmed? Okay, well, the nature maybe is not quite that bad. Maybe the other person in that case had screamed something terrible and called the defendant terrible names right before. So that sort of mitigates it. You know, it makes it less provoked. Maybe it's not a complete defense. It doesn't mean that you're not guilty, but it does mean, okay, you know, this was not absolutely terrible conduct on the defendant's part if everything that was presented at the hearing is believed. Two, facts of the case. This kind of goes along with nature of the offense, but nature of the offense, we're looking more at like how violent was it, for example. Facts of the case are more, okay, was anybody injured, for example, if it's assault with a deadly weapon, or how bad were the injuries if it's a 273.5 corporal injury to a spouse or cohabitant. The third thing that the judge will look at is criminal history. So if you have no criminal history, that is something that your attorney would want to bring up. And number 4 is your personal history. So this is work, school, family life, all the good things about you. If you have health issues, those maybe could be brought up. Sometimes immigration, depending on the consequences and the circumstances, might be brought up. And the attorney argues all of these things to the judge and asks the judge to reduce the charge to a misdemeanor. Now, if it is reduced to a misdemeanor at this period of time, that is so great for the defendant because, like I said, this is at the end of the pretrial stage. Everybody's been negotiating. Nothing has been working. The DA has not offered the defendant something that the defendant wants. So now the defendant's about to go into the trial stage. Now, trial is scary because if you lose, you could get the max. And many times you will get a much worse sentence than was offered to you beforehand. So if you can get it reduced to a misdemeanor, I mean, the maximum amount of jail time for a misdemeanor is 364 days in jail. So now the stakes have gone way down. Your leverage has gone way up. And the chances of getting an offer that you want from the prosecutor increase significantly. Because instead of them holding, 2, 3, 4 years of prison over your head, now it's like, hey, the best you guys can get, you thought this was a felony, the best you guys can get is you send me to the county jail. 364 days, you'll usually do 10%. I mean, that's best case scenario for them. And the judge is kind of giving them an indication like, hey, I think you guys should, really maybe let this one, give this one some grace, give this one a second chance by granting that motion. Are these motions granted frequently? They are not, but I have had some success recently in getting these motions granted. I think that judges right now, I made a video about how sometimes they're rejecting plea deals because they think they're too lenient. But I think that along with that, they are looking at the cases much more carefully. And sometimes defendants can use that to their advantage. So I hope that this helped. I hope that you learned something here. And if you have any questions, feel free to go ahead, book an appointment with me or give me a call.